Hi everyone, it's Sharné from Enterprise Legal here. Last week the legislation in relation to this JobKeeper payment got passed, and since then I've had a number of questions from clients around some, I suppose, finer details or nuances in relation to the legislation. So I thought I would just do a quick video touching on some of those key questions that I've been asked and what some of those answers might be. Basically, for those who don't know, on the 30th of March 2020, the Australian government announced their wage subsidy, and they refer to it as the JobKeeper payment. It's a subsidy for businesses who have been severely and significantly impacted in an economic manner from COVID-19. So the JobKeeper payment, there was a lot of, I suppose, speculation out there in relation to how it would look and how it would be passed on to the employer from the government and then from the employer to the employees. And some of those questions have now been answered. So basically it operates at a high level. There's an act, there's a JobKeeper payment, or it's called the Coronavirus Economic Response Package. Sorry, I'm just reading it. Payments and Benefits Act. And that act basically just allows the Treasurer to make the specific rules around this payment, and it authorises the making of the rules of the payment. And then there is the Coronavirus Economic Response Package Payments and Benefits Rules. And it's in the rules where a lot of the finer details and answers to some of these questions lie. So I've had a quick read of the rules, and look, there are still some parts of it that's not 100% clear, and that will probably be fleshed out and answered through the coming days and weeks. But in essence, the rules specify that the JobKeeper payment, which will be an amount of $1,500 per fortnight, which was kind of widely known before the rules were published, will be made available in fortnightly periods between 30 March 2020 and 27 September 2020. So that's basically a period of 26 weeks or 13 fortnights, and that's basically to just reflect the, I suppose, short-term purpose and stimulation of the economy by the federal government. I suppose a short-term goal to help businesses out who are significantly impacted by COVID-19. In a nutshell, basically, the businesses that are entitled to the JobKeeper payment will receive this fixed payment of $1,500 per fortnight per eligible employee. And it's very important that all employers and all businesses know that that amount has to be passed on exactly like that to all employees, whether that employee earns the same, less or more usually than that amount. What I won't go into today, and certainly won't endeavour to go into, is the eligibility and all the criteria and the tests around whether you're an eligible employer, whether you're an eligible employee, those types of things. Look, it is actually a really complex area of law, legislation and accounting principles, and so it's not something that I'm going to endeavour to do a short video on. I think that would be remiss of me, and it probably wouldn't do justice to the very important topic that it is. So I would strongly encourage all businesses to certainly go and see your accountants, work very closely with your financial advisors, or mostly probably your accountants, around, does your business qualify for this? How do you work that out? How can you demonstrate that? What account keeping or what records do you need to prove, etc., etc.? What steps do you need to take on a monthly or fortnightly basis, or whatever the case may be? And then certainly equally go through kind of your different employees and what that would look like for all of them. From my perspective, if you can afford it, and understand that at this point in time that may not be possible for a lot of businesses, but if you can, it is always a good idea to have these conversations with accountants and lawyers jointly. Lawyers very much interpret the legislation from a technical legal background perspective, and they add a lot of value in that regard, in their interpretation of relevant sections and operations and the intent of legislation. Sometimes it could read at face value in one way, but if you start reading the explanatory memorandum and so on, lawyers may form a different view. Accountants obviously will be very relevant, extremely relevant, and probably more relevant than lawyers in this space at the moment, to try and work out whether your business can qualify and what the figures look like and how they stack up and cash flow and trajectory and all those types of things. So, you know, if you can't afford to see both, that's fine. Certainly reach out to your accountant. That would be my advice. I've had employers who've asked whether they can, I suppose, select which employees qualifies for this payment, or which employees they, I suppose, opt in relation to receiving this $1,500 payment. And I suppose at a very baseline, the answer is no. If you are an eligible employer and you've put yourself forward as wanting to apply for the JobKeeper payment scheme and you qualify for it, then all eligible employees have to receive that payment. You cannot elect which eligible employees receive it or don't receive it, but obviously what you've got to be mindful of and continue to assess is which employees are the eligible employees and are there any exemptions that apply to them in that regard. But I think that the government has referred to it as a one-in, all-in rule. That's how they refer to it. So that's very important to keep in mind when having these discussions. You need to look at it as a full picture. You need to look at all of your employees, those that's been stood down, those that's working in a part-time or in a part capacity, and also those that's working in a full capacity. And then you need to look at what that looks like. That is a package. What does that do to your cash flow and figures and all the accounting side of things? And then you need to make an informed decision, I suppose, whether you want to opt in or opt out. Another question I get asked often is, there's a lot of information floating around, when do you have to assess whether your business is eligible by? There's a lot of talks about fortnightly assessments. There's a lot of talk about it on the 1st of March, certain eligibility criteria, and there seems to be a little bit of confusion around that. The short answer is both. There's 2 tests and you've got to meet both tests. There's a 1 March 2020 criteria test you've got to go through and make sure you meet. And then, as far as I understand the legislation, every fortnight there will be, or it's called JobKeeper fortnights or something along those lines. And basically, you have to continue to meet certain eligibility and criteria throughout, and so do the employees, for you to be eligible. And that just makes sense from a common sense perspective. I mean, you can imagine if an employee obviously gets terminated in 2 months' time for whatever reason, or they hand in their resignation, that employee then obviously doesn't meet the criteria anymore because they're not an employee of your business, and subsequently the business won't qualify for a JobKeeper payment for that specific employee. Now, that's a very basic explanation. I'm sure there's lots of other sort of scenarios that could crop up, which is why there is certainly an ongoing reporting obligation on employers to make sure that they remain eligible. The big one that I've been asked is whether casuals qualify for this payment, and if so, which casuals. Now, I suppose it's easy to read all the articles that's out there. They all basically say you're only allowed if it's full-time, part-time employees, or if you're a long-term casual. Now, a long-term casual is now being defined by this legislation, or the rules, I should say, as a person who has been employed by the employer on a regular and systematic basis during the period of 12 months that ended on 1 March 2020. So basically 1 March 2019 to 1 March 2020 was the casual employed on a regular and systematic basis. And this is, it's similar to the Fair Work, the previous Fair Work tests around when someone's a casual, when someone qualifies for applications like unfair dismissal and so on. And it's actually quite a tricky concept. It is important for you to realize and know that regular and systematic it means regular and systematic work. It doesn't mean regular work hours or regular work patterns or a pattern of work that you can follow with a degree of accuracy. It's actually more looking at, has that person or has that employee been able to say, look, over a period of 1 year, I have on average received 2 to 3 hours, worth of work per month, or something along those lines. And if the answer to that is yes, then you do have to question and probably look further into whether that employee is a regular and systematic employee and whether they meet that casual criteria. Another common question that I get asked is, what if I've got casuals on the book or part-time employees on the book and they receive less than the $1,500 a fortnight? Quick answer is you've got to pay them the $1,500. So in essence, you're paying them more than they would otherwise get, but that is certainly the JobKeeper payment that they are entitled to and that they're eligible for. That is the amount that you will receive, and that's the amount that you've got to pass on in full to your employees. Now that amount is, it's $1,500 before you deduct tax and other salary sacrificing sort of entitlements and so on. And then the other really big one that we get asked quite commonly is superannuation. Do I need to pay superannuation to these employees? And if so, what does that look like? The short answer is that the rules actually cannot make or amend the superannuation legislation. So it hasn't formally been legislated, what I'm saying now, but it's been indicated in the explanatory memorandum of these JobKeeper payment rules that superannuation will have to be paid on those hours that the employee is usefully being employed. So if you've got a staff member that's been stood down and they're doing no work in your business and you're paying them the $1,500 purely that you're getting from the government and then you're passing that $1,500 on, they know you do not need to pay superannuation on that amount. If, however, you have a staff member that earns a regular salary of $2,000 a fortnight and they continue to work in your business, you need to pay that staff member $2,000 and you need to pay that staff member superannuation on the $2,000. So there's no discount or a way that you can take into account, I suppose, the $1,500 as a JobKeeper payment's not entitled to superannuation, but then the top-up is. Then there's the third scenario, which is, okay, an employee works for your business, but you've used some of the directions that you can now use under the bill that was recently passed in that regard because of the JobKeeper payment eligibilities. So you've issued a direction, the employee is working less hours in different duties in your business. So let's say they only work about $1,000 or $700 worth of fortnight worth of work. Then what you've got to do is you've got to top them up to the $1,500 for each fortnight. But for the top-up amount, you do not have to pay superannuation on that top-up amount, but you do have to pay superannuation amount on the hours that they worked for the business, whatever that amount looks like. So if they've worked, I suppose a total of $1,000 worth of work, that's got to be calculated in accordance with the employment contract or the relevant award or EBA or whatever the case may be. Then that amount they do have to get paid superannuation on top of that. There's also this other component to JobKeeper that is not as talked about by people, but is actually quite a useful tool, and it's the changes that have been made to the Fair Work Act. So basically, if you qualify for JobKeeper payments, which would obviously mean that your business has been impacted to a sufficient, I suppose, degree economically because of COVID-19, then you can also now make directions to employees on a number of things where you ordinarily would not have been able to. Things like you can reduce the hours that they work for your business. You can reduce the job that they do, provided that whatever alternative job you're giving them is safe and they can carry out and it's within kind of their duties and skills. You can change the location of where they carry out these tasks, and so on. So there's a lot of actual flexibility without going into a chapter and verse. There's a lot of flexibility that you now have, provided that you are eligible for the JobKeeper payment, around each staff member and employee, to try and, I suppose, make the best use of which employees you've got working where and how and when, and how does that translate to the cash flow of your business, and how does that all work in with the JobKeeper payment that's coming in, and so on. So that's certainly a useful thing, because obviously ordinarily you're required to do one of three kind of things: perform the employment contract as per the contract or the award or the EBA, or otherwise stand someone down if you're legally able to, which means they don't work for you at all. They're still an employee of the business, but they're not working on or in the business. And or of course then make them redundant. It's always another third option. With redundancies obviously comes significant redundancy pays that's got to be paid to the employees, and there's a lot of other impacts to consider when I'm going down that path. So these new amendments to the Fair Work Act that allows this flexibility around you know, how you're going to use your employees to kind of the best of both your and their benefit is certainly going to be useful in the employment space. And so that's it from me, guys. I hope that some of the questions that I've answered has been useful. Certainly, as more questions will no doubt crop up over the next coming days, we'll see if we can put up another video addressing those. If you've got any other questions or you want clarifications, please send us an email and we'd be happy to point you in the right direction. Keep well and stay safe.